Пані Вікторія, добрий ранок.
Victoria, good morning.
Чуєте нас, бачите?
Can you hear and see us well enough? Yes.
Конкурсна комісія
So the
вітає
Selection Commission is welcoming you at the second stage
до Вищої
of selection to the High Qualification Commission of Judges of Ukraine. The interview is conducted by the commission, by all the members, Stephen Markman, me, Ivan Mishchenko, Yevhen Mesentsev, Serhiy Verlanov, Ted Zajachny, and Robert Brookhuizen.
доповідачами на
The
ваше
rapporteurs at your interview are Stephen Markman and Yevhen Mesentsev.
Пані Вікторія, якщо з якихось
Victoria, if for any reason
наша співбесіда буде перервана внаслідок
the
відсутності
interview is interrupted due to technical reasons, lack of connection, or due to alarm or power outage, we will stop the interview, reach you, and shift it to the other day and time. And there will be additional information on that, and we will coordinate this with you. So don't worry in case something happens for technical reasons. Please, we would ask you to give concise answers to the core of the matter. I hope that you have got ready for the interview, and the member of the commission asking the question can actually limit the time of your answer.
власне початком інтерв'ю чи
Before the interview, or rather at the very beginning of the interview, you will have a chance to tell about your motivation for participating in the selection procedure, about your ideas, the main things about you that you want the Commission to know and to appreciate.
на цьому переходимо власне до
With this, let me start the interview. Let me give the floor to Stephen and Yevhen. You're welcome.
Good morning, Judge Lomaka. Thank you for participating in our competition. And as we typically do, we'd like to give you up to 5 minutes if you'd care to talk about your background or your motivation or anything else that you think we need to know about you. We're, of course, aware that you've been on the commercial court in Ukraine since 2011. And you have a considerable judicial experience as a result, and we look forward to meeting with you this morning. So please take up to 5 minutes and share with us what you think we might be interested in hearing.
Good morning. It's a pleasure for me to participate in this interview with the dear members of the distinguished members of the Selection Commission, and I will try to tell about my key opinions and ideas on the reform of the judiciary and about the moral and ethical standards of every judge. I hope that these principles and views will be heard by all those who are watching the interview.
На шляху мого становлення та розвитку як фахівця у галузі права я виконувала не лише
I have been performing not only my job, my functional duties, but I've been trying to ensure my self-development, following the psychological portraits of judges in Ukraine and the changing level of legal awareness and conscience. And that helped me to develop the vision of what a real, responsible, independent judge should be like. What the skills, moral, ethical standards of judges should be, what standard of integrity they should follow. And this coincides with my vision of the independent judiciary. I've been trying to ensure my self-development. I've been trying to develop better concepts of the independence of the judiciary following the job I have, the position I have. The requirements of the society concerning integrity, concerning moral and ethical as well as professional competences of judges are something that I like very much, because it is really on the level of integrity, moral and ethical skills and responsibility of the judge that the level of trust in the judiciary among society members depends on, as well as this predetermines the general perception of Ukraine in the international community. I strive for self-development and for the chance to implement my vision, the reform of the judiciary. and my striving to be involved in the reform of the judiciary. And these are the things that have actually driven me to to apply for this position of a member of the HQCJ. And I'm sure that my level of knowledge, my moral and ethical achievements fully correspond to what is required for this position, and they will help me work with judicial candidates, with judges, and they will help me to be involved in the reform of the judiciary as a member of the HQCJ. I want no alien observer to have any doubts, not to have any doubts that the rule of law really exists and that laws are complied with by everyone with no exception. I'm persistent, I'm responsible, and I've got analytical thinking skills, and that makes me assure the members of the Commission that in case I'm appointed a member of the HQCJ, selection of judges will be not implemented in a hurry through some reattestation, but it will involve deep analysis of every judicial dossier, every judicial candidate or incumbent judge. I understand that the scope of responsibility and the tasks, the objectives of the would-be members of the HQCJ are really extensive, and I'm ready to work there. Thank you.
Thank you very much, Judge Lomaka. Let me ask you about a process that I haven't had a chance to read much about from judges who've gone through the interview procedure here. But you say that you passed the special check according to the law of Ukraine on the lustration of power earlier in your career. Can you explain how that process works and how it's triggered?
Дякую за запитання.
Thank you for the question.
Відповідно, була розпочата процедура
The
щодо
procedure
очищення
of lustration of power was launched to fulfill the requirements of the law, and the documents of each candidate for inspection were sent to the competent authorities, and these were the state service of the judicial administration, the tax inspection, the Ministry of the Interior, the security service, the prosecutor's office, the general prosecutor's office, and all those bodies were to provide their opinions concerning this person. And if there were any remarks or any questions, the judge had a chance to provide written explanations. And on the basis of the results of this inspection, a certificate was issued about the results of passing or failing. Thank you. That's it.
Was there any particular reason why the process is triggered in any case, or is it applied across the board to everybody at a certain point?
Thank you for the question. That was the general procedure. The law was enacted, and all judges, in particular judges of the Commercial Court of Kyiv, had to take this inspection, whether they comply with the requirements of the law on the lustration of power. And I think that I have been a success with this inspection because all the competent bodies did not ask me to provide any written explanations. They didn't have any remarks to me.
Okay. Judge, you've indicated your hesitation to involve yourself in the selection process for judicial institutions until you have pursued this particular position. What is it about your current situation and your current awareness of issues that's caused you to think that this is the right time for you to pursue this very important position?
Дякую за запитання.
Thank you for the question. Let me mention that currently I'm deeply convinced and I'm motivated to work if I am elected a member of the HQCJ, since the scope of knowledge and the achievements that I have got could be useful now only in the courtroom when I hold court hearings and pass decisions in the name of the Ukraine, working, of course, within the law. But along with that, I would like to join in the process of development of the judicial staff, of the judiciary, of the corpus of independent, impartial, and responsible judges. Therefore, I have a certain vision of this issue. I've given it a serious thought. I've thought about qualification assessment and reform of the judiciary and strengthening of the level of trust in the judiciary. Thank you.
You would be comfortable engaging in qualification assessments of colleagues and judges with whom you interact typically on the court?
Thank you for the question. Yes, I'm ready to undertake this responsibility and to be involved in the qualification assessment, in particular, qualification assessment of judges I work with, since I'm not in close relationship with most of them. That's why there are no private interests involved in that. There is no conflict of interest that would cause my frequent self-recusal the way it's required by the applicable legislation, or I wouldn't have to notify the Council of Judges about a potential or available conflict of interest.
Judge Lomaka, let me briefly ask you a couple questions that do pertain to integrity. These are questions that we would typically be asking of candidates in the process. According to your declarations, you possess a car, I think it's a Mercedes-Benz 2021, belonging to the partner of your mother. He apparently purchased this car for 2.8 million hryvnia, and you explained the use of this property in paragraph 5 of your motivation letter, namely the good relationship that you had with your mother's partner, and the fact that he allows you to use the car for your own purposes when you choose to do so. But you didn't indicate the value of the car in your declaration. Why would that be the case, please?
Thank you for the question. The owner of the car has not informed me about the full value of the car. I mean, I had an idea about the indicative value, but I didn't know what the full cost of the car was, value of the car was. I had some concerns because I was afraid to make a mistake, to indicate the wrong value that could, since that fact could actually have a bad influence on me. And since I didn't know the exact figure, I did not indicate it. I told that I don't know what the exact value is. But the approximate value is known to me.
But you thought it was better not to make a mistake than to, you thought it was better not to put any value than to make a mistake, is that right?
Well, thank you for this clarifying question. There could be a major mistake, because indicative value could differ from the real value of the car.
But you say you know the value now, is that correct?
I was not informed about the correct value because probably this person didn't consider that it would be right if I knew the exact value. And I came to know further information only after I got the dossiers materials. As far as the indicative value is concerned, well, I knew it not from this person, but just because I can figure out what the market value of this car is. And if you go to the car saloon, you can also find out the approximate indicative value. But I didn't have a chance to know the exact data. That's why I didn't indicate it.
Let me ask you about another car, too, if I might. In the same declaration, for the years 2015 to 2020, you noted that you also had a right to use a 2011 Lexus car owned by your mother's partner, I think the same gentleman. You did not, again, indicate the cost of the car. However, during the interview, as part of the qualification assessment, you reported that your mother's partner bought a car in 2011 for 580,000 hryvnia. At the same time, his income for the period from 1998 to 2011, the preceding 13 years, was about 201,000 hryvnia. Thus, there's some question about the source of the funding for that car. And I guess I would ask you what was the reason for not indicating the value of that car either in the assets declarations?
Дякую за запитання.
Thank you for the question. So concerning this issue, let me explain the following. Valery Vasilievich, I mean the partner of my mother, has been an active businessman since 1997, and the certificate of registration as a sole proprietor has been provided. The tax inspection's certificate shows, but unfortunately the form in 2022 was changed a little bit. And in the certificate itself, it's not clear that he was paying taxes, single tax, within his entrepreneurial activity. He was also either the director or deputy director of some agricultural company, which is limited liability company, Ukraina. And this money and the savings gave him a chance to buy this car.
Okay. Well, let me move on to my co-rapporteur, if I might, Judge Muzientsov. He may have some further questions for you.
Okay. Thank you, Stephen. With my pleasure.
Victoria, good morning. I'm Yevhen Mezentsev, and let me also try to ask you some questions concerning the context, which has evoked some remarks with the Selection Commission when we were preparing the materials for the interview. So for the broad public, let me mention some of the facts from your questionnaire for this information to come to be known. And you were born in 1984, you are a PhD, you presented your thesis in 2011, and your alma mater is the National Law Academy of Ukraine, named after Yaroslav Mudry, the same as for me. It is my alma mater. You are the judge of the High Commercial Court of Kyiv, and you participated in the competition for the Pivnichny Court in 2019, and objectively you could not undergo this competition, this selection, and the reason is known. That's one of the reasons why we meet here today. You worked as an assistant judge, and since for some years you did not perform justice because the term of your office was over, it expired. You have a fluent command of the Ukrainian language, certificate of the first degree, and you got this certificate on the 4th of October. Victoria, so let's complete your input data, so to say, and let's go back to the questions that you don't feel like answering today, of course. Concerning the value of the property you are using, well, to tell the truth, it seems to me that you are already sorry that you have not indicated the value in the declaration, because you wouldn't have to provide long and extensive explanations, right? But here is the question concerning the level of income of Mr. Spak, the partner of your mother. With all my respect, of course, if you are a well-to-do person, this is a good thing. But in the period of 1998 up to 2011, according to our data and the data from the State Tax Inspection, his income over the period of 13 years until 2011 was 200,000 and something. And that's why we've got the issue wherefrom he had money for the acquisition of the car you've been using, Lexus, and the car you are using now. Can you tell anything about the additional sources of income of the partner of your mother, besides what you have just explained, that he was director or deputy director of some limited liability company, or you don't know anything more about that? Well, thank you for the question. This is what I actually know. I just know that Since 1997, he has been an active entrepreneur. And as I analyzed the legislation while getting ready for the interview, he actually had an opportunity to pay for the patent. This was a fixed patent for entrepreneurial activity and for retail and wholesale activity. And from the tax, I failed to get the information on the basis of the tax reports, but I addressed the tax inspection asking to provide the confirmation of his entrepreneurial activity of that time, but I didn't get any positive answer. But I took the actions to get this information. Unfortunately, I failed to get it. Well, our concern with this issue is not ungrounded. You have to realize this. The business in the 90s was a little bit different and involved different methods and different reporting than now. But we have to ask about this to clarify this for us and for the public. You have to realize this. Even if this is not a claim against you as a civil servant or the assistant judge and judge, but anyway, this is a concern about a person who is your relative. Here is another question concerning the apartment in Urivska Street. It was purchased when you were 24 years old, and you have mentioned that the investment into this apartment was made by your mother. Back then, your mother had income over the period of 10 years, 110,000 hryvnias of official income, but the apartment in Urlivska Street, the value of it, according to the data we've got, was 245,000. So what could you tell about this apartment and about the sources of your mother's income? Thank you for the question. As far as this question is concerned, let me explain the following. The apartment was not bought by my mother. I graduated from Kharkiv Law Academy and was referred as a young specialist to the High Commercial Court of Ukraine. And when I worked there, I had an opportunity to get this apartment from the state. So this apartment was not bought by my mother. Please specify it once again. And was it given to you by the High Commercial Court? Is it the kind of functional flat? At first, it was the functional flat, and then I privatized it. You privatized the apartment that was given to you within your job, right? Yes. You also declare that you're using the apartment of your mother in Zaparno-Slobodska Street, and the value of the acquisition of this car is not indicated either. Why? Thank you for the question. It's true that I'm using the apartment of my mother. I started using this apartment because it is located closer to the place of my work, the High Commercial Court of Kyiv. And since my apartment is located on the left bank of Dnipro, and it's more distance from subway, and it's about 10-minute walk to subway. So I passed the decision to use this apartment on work days, in particular on the days when I have to go to some court hearings or when I come home late after court hearings. So on those days I stayed in the apartment of my mother, and that's why I declared it. And does your mother also reside at this address? Thank you for the clarifying question. My parents do not live in Kyiv. In particular, my mother lives in Kropyvnytsky. That's why when she comes to Kyiv, of course, she resides in this apartment. But the goal of acquisition of the car was, either the opportunity to be able to come to Kyiv and further on to be closer to me, because already back then I understood that I would be living in Kyiv and I would not be intending to go back to Kirovohrad, which is now Kropyvnytsky. It has been renamed. Thank you. For the alien observers, let me also say that according to our current data, your mother has 23 land plots and her partner owns 17 land plots. As far as I understand, these are agricultural areas or what? Thank you for the question. That's true. They have some agricultural activity, and it should be noted that there are some land plots that were inherited by them. And since the period of time when agrarian business started developing in Ukraine, they were among the first to do the entrepreneurial activity in the agricultural business, and that caused the number of this number of land plots. Clear. Thank you. Please tell us the following. And the question is actually asked by civil society organizations. They note that one of the people who have given reference letters for you for this position is Nadia Hubanko. Is it right? Yes. So concerning this lady, civil society organizations have some, not claims, but they were preparing some negative opinion. I mean, Public Integrity Council was preparing a negative opinion of her. They did not agree to some decisions, but we will not discuss the decisions as for now. But among other claims, other remarks, they said that in her declaration, the value of some property is also not indicated. So could you please tell us, what is your relationship with Mrs. Hubanko? Thank you for the question. Let me explain the following. When I was writing my motivation letter and when I was preparing the reference letters for this selection procedure for the HQCJ, I also worked with all open sources I could find access to in relation to the people who provided reference letters to me. And as far as the negative opinion of the Public Integrity Council is concerned, I knew about that. But we're not talking about the negative opinion. Let's somehow distract from it. This is not the subject of our today's discussion. We are not assessing Mrs. Hubanko in any way. But what about your relationship with Mrs. Hubanko? What kind of relationship is it? Thank you for the clarifying question. It should be indicated that we have work-type relationship. We got acquainted in 2008 when Mrs. Hubanko was transferred from the Kyiv Appellate Commercial Court to High Commercial Court of Ukraine. We worked in one chamber. We considered some type of cases. And while working together, we had a lot of discussions of the materials of cases. We had some consultations on the judicial practice, and I liked her approach to the study of the materials in the case, her approach to analysis of the application of the applicable legislation, and the motivation part of decisions of different courts. And this enabled me to develop some work relationship with him. Thank you. Here is another question concerning your professional competence. We pay attention, not only in relation to you, but in relation to any candidate, to availability of some claims coming to the High Council of Justice. Me, as the judge in the capital, can tell that if you haven't got 2 claims a year, this means you haven't been working. But there were several claims against you. In particular, in 2018, there were 2 claims. One claim came in 2021, and now in 2022, there was a kind of a collapse. 21 claims against your activity within 1 year. And there was no decision passed on the merits of the case in any of those claims. But is there any reason for such a great number of claims, which is not typical even for a judge working in the capital in 2020? This is the year 2020, yeah. Thank you for the question. That's true that in 2020 there were so many claims against me, and these were the claims or complaints that as I think, and as I explained in my explanations, was related to one of the cases based on the case related to the interests of the military unit about the charge of the cost of works that were not performed. So was it kind of procedural sabotage? What was the goal of the people who were trying to submit so many claims in the case you have mentioned? Well, if we have a look at the decision of the High Council of Justice, even it, in its decision, indicated that it sees those claims as the way of urging a judge to pass a certain decision. Probably they did not agree with my participation in this case in general. So you mean that they were trying to urge you to make recusal? Yes. And the court of our instance considered this case, and the cassation court reconsidered them, and that was not substantiated. Did you respond to those claims in any way following the legislation concerning the interference into your judicial activity? I didn't think that this was direct interference into my activity. Well, they were just enjoying the right within the Code of Commercial Procedure. They have the right for recusal, for any claims mentioned in one of the articles of this code. So they were trying to appeal my decisions, but the judges of the appellate court were assessing the case then. My colleague has also mentioned what I actually wanted to ask you, but it's clear that this is the right to recusal, but, you know, several tens of recusals within 1 week for the same reason or for different reasons by one person is normally considered to be an abuse of power, abuse of this right to recusal. And actually, some measures should be taken, including the measures envisaged by the Code of Procedure. You either impose some fines on the person who is abusing this right, or you give those claims back. But you didn't respond. Well, thank you for this question. There were only 2 recusals. The first recusal was in January, and the second recusal came in in September, if I'm not mistaken. First at the court meeting, and then orally, and then on the basis of the party's request, it was done in writing. So I don't think that there was any abuse of this right or abuse of power. But the appeals against those recusals, well, that was the matter to be considered by the cassation court, because still such complaints, according to the Code of Procedure, do not actually lead to any results. And I think that in a similar situation, generally, that may show that there is some abuse. All right. Viktoriia, what do you think? What are your weaknesses or bad traits of character, some faults of yours you would like to overcome, or probably you're trying to overcome now? Thank you for the question. Well, of course, I have got faults and I recognize them, and I think that my biggest fault is, I'm sorry, I didn't hear you, the inspection of what I'm doing. Of all my actions. Let me explain what I mean. Sorry, Viktoriia, the point that you have some self-control in place is not a weakness. Weaknesses could include lack of responsibility, lack of control, apathy, revenge, intolerance, I don't know, lack of confidence in some context, indifference probably, lack of empathy. Well, these could be weaknesses, but what about those characteristics? Do you see any of them in you? No. I cannot characterize myself as a person with any of the features you have mentioned. Oh, at least you wouldn't be willing to see that you have them, right? What about the context of my question? It is known that in the law of Ukraine on the judiciary and status of judges, there is, among other rules of assessing selection procedures, the rule that if two candidates get the same score for a certain task, or generally in the course of the selection, in this case, the priority will go to the person who is the judge. Or if both of them are judges, the priority will be given to the person with more years of judicial experience. Or if both of them are not judges, the priority will be granted to the person who has a longer work record in law. What do you think? Is this approach fixed in the law not discriminative by professional, by age characteristics? Because a person is not to blame that he or she worked only for 3 years and the competitor who got the same score worked for 6 years in the judiciary up till that point of time. This is objective data that cannot be changed. You cannot make your work experience 15 years longer. This is just the duration of your work. So don't you think that this approach is discriminative? And thank you for the question. Well, yes, I think that there is an element of discrimination in this, because if people involved in the competition get the same score and have shown the same level of knowledge, they cannot be differentiated by the years of work experience. But according to the law, they can. So we just want to hear your opinion and not the norm of the law, because so we can read the norm of the law. Thank you for the clarifying question. I'm now talking about my internal vision. Okay, thank you. Let's think it over. For example, if the High Qualifications Commission of Judges of Ukraine and its future composition developed the methodology following which psychologists would have to assess every candidate not in terms of his virtues or her virtues like high professional competence, integrity, and other things like that, the best traits of character and the best characteristics, but would try to assess through a specific test the worst characteristics of the person and make a conclusion, even if this conclusion and opinion is closed for the broad public. And the results of this test would show what the negative characteristics of this person are. And if this test was arranged, wouldn't you think that it would be just if the candidate in the situation I have mentioned would leave in case he has more negative characteristics, or if they are better manifested? Would it be fair?
Thank you for the question. I think it would be fair. In general, I've completed psychological testing. I've undergone an interview with a psychological, and I was aware of the opinion that the psychologist has made after this interview. I do believe that this is a positive thing, both the testing and an interview with a psychologist. They give us the opportunity to discover those weaknesses that a judge or a candidate judge may not be able to see in themselves or do not even consider to be weaknesses.
Mr. Chairman, it's my turn.
If you wish so.
Fine.
So go ahead.
If you don't mind, I will say Victoria. My name is Robert. Victoria, in your motivation letter, you say that the successful completion of the judicial reform in Ukraine is directly connected with professional selection of competent, impartial, and conscientious judges. it is the meaning of the judiciary with qualified, non-corruptible and apolitical professionals capable of constant development and self-improvement. Do you recognize this line in your letter?
Так, дякую.
Yeah.
Yes, I do remember this quotation.
Now, part of this interview, we have been busy with questions to you regarding your assets. And you have given quite a lot of explanations. And I just wanted to share my views on that. You drive a Mercedes, and I just searched this Mercedes on the internet in the Netherlands. And in the Netherlands, it costs around 100,000 euros. And if I say to you that judiciary and to be a judge is not only about to be honest, but also that you are seen to be honest by the people you give, you're asked to decide if they have issues. And my question to you is, do you believe that a judge that drives a car which has a value, I don't know what it is in Ukraine, of 100,000 euros?
No, it's about $100,000.
100,000, well, in any case, a fortune, is seen by the people in Ukraine as a honest and impartial judge. Especially when I take into consideration that what the average income is in Ukraine, I'm not sure how much that is, but it's below 10,000 euros per year. And you come, you go to court, and you have a car of $100,000. And the question to is, does that reflect impartiality and incorruptibility?
Дякую за ваше запитання.
Thank you for your question. Yes, indeed, an outsider may be having some doubts about impartiality since I do drive this kind of car. But at the same time, I declare this car. I declared the right to use the car. It was mentioned in my motivation letter. So in this way, I showed my openness both for the commissioners and for the outsiders. It should be mentioned that I don't constantly use this car. At the same time, I live alone and I spend the money that I make on me alone. And if we look at my official salary, I'm able to save and buy an identical car. Maybe a car that is a little bit cheaper. Maybe a car of a different make, but still.
Okay. Yes, you mentioned the car in your motivation letter, but the fact is that it has not been declared. I don't know exactly where, but you say it is transparent, but the car was paid by the friend of your mother. I don't call that transparent. Let's say that we have a civilian in a dispute with his neighbor about something between the ownership of a house or something wrong with the garden or a divorce or whatever. And they drive to court and they come with their ZAF 100, a small, let's say, Ukrainian car. And they go to court and your car is, they park their car, they walk out of the car and you drive in the court and you come with your Mercedes with a value of 100,000 euros or dollars. What do you think those people think?
Thank you for the clarification. I understood your position and your view of the situation. I will think about it. And maybe I will try to use this car not as much as possible. So I will only be using it not when I have to drive up to the courthouse. Maybe an outsider
відчуття якогось
will feel as
низького рівня моєї доброчесності.
if I don't have enough integrity since I'm driving a car which is much more expensive than their car. But at the same time, me having a good relationship with the owner of the car, I'm able to use it at times when he doesn't need it, and that's what I've been doing. Thank you.
Well, I don't say that you are not. The only thing that I say to you is that justice also must be seen to be done, which means a parent's appearance is important.
Дякую за ваше зауваження.
Thank you for your remark.
Єдине можу зазначити, що
The only thing I can say is that I'm aware of how justice is administered, but
зателефонувала тому
from the very moment that people show up at the court, they appear before me during court hearing, when I'm presenting the motivations for the decisions that I make. I do believe that this is me showing my impartiality, my independence when I'm making the decisions in the courthouse. As far as the car is concerned, so I will look deeper into this issue and will make specific decisions in this regard. Thank you.
Okay. I can tell you that in the Netherlands, which is one of the richest countries in the world, where the average income is maybe between 5 and 10 times as high as in Ukraine, the judges are paid quite well. I don't know any judge who drives a car of this value. It doesn't exist.
дякую. Я не є власником даного автомобіля.
I'm not the owner of this car, and since the owner doesn't really use this car, or he uses it very seldomly, so we are talking about the year 2022. Well, in 2021, he did not use it very often, and I did not need to buy a car of my own.
Отримувати два автомобіля від
Because if you have two cars, they lose in their value. That's why I didn't buy my own car. Thank you.
Yeah. Well, in your motivation letter, you say that you qualify for the HQCJ and that we can entrust you with that because you are non-corruptible, impartial, conscientious, and demonstrate impeccable conduct also in your personal life. The point is that we, of course, we have to select people who are not only impeccable, but also that the people in Ukraine must believe that they are impeccable. And how can we believe that you are impeccable and you don't have any difficulties when you drive around in such an expensive car? I don't say that you're not allowed to do it. That's not my. I don't say that. Of course, you can do whatever you like. But if I'm a foreigner in this commission and I look at it with my eyes, which may be wrong in culture or whatever, then I think, why do you do this?
Оскільки в моїй власності не перебуває
Since I don't own a car, I did not buy a car for myself. The car that was given to me, that's the one that I'm using.
Okay, I have no further questions.
Judge Lomaka, a number of candidates have discussed with us, usually because we ask questions about it, the issue of gender equality. Now, you obviously are a good example of the increase of the number of women who hold judicial office in Ukraine. And it seems to me that there is positive progress being made in that direction. I'd be interested in your ideas, if you have any thoughts about this, about what the High Qualification Commission could do, if anything, to increase or encourage the number of women to be judges and to appoint more women judges. Do you have any views in that regard?
Thank you for the question. I believe that, first of all, we have to select people who are professionals, people who have integrity. I don't think we should be giving any preference to anyone as far as gender is concerned. But if we analyze the number of judges that are working at the commercial court of the city of Kyiv, I do believe that we are complying with the principle of gender equality. At the same time, as far as this selection is concerned, if we analyze the number of candidates who reach stage 2, if we analyze the number of men and women, I do believe that the principle of gender equality has been followed. I don't think that we need to ensure this principle in some specific way. If a woman is professional enough, if she has the moral and ethical qualities, then she should be appointed, but she should not be given preference based on gender.
Thank you. There's another interesting area that I looked at in your motivation letter, and we all study these letters very carefully. And you make a statement in paragraph 8, or in answer to question number 8, that you want to work with public authorities and their officials aimed at preventing ungrounded accusations, humiliation of the judiciary, and other, if you like, negative opinions. Now, I looked carefully and I did not see any reference in your motivation letter to the role and function of the Public Integrity Council in the work of the High Qualification Commission of Judges. So is that what you were referring to when you made the statement about concern that there not be improper and unwarranted accusations against judges, or was there something else you had in mind? But more importantly, what is your view of the role of the Public Integrity Council with the High Qualification Commission of Judges? Is there anything you would change about the role and function of the PIC?
Thank you for the questions. Yes, while I was writing about the government authorities, I meant the government authorities. I meant the institutions that are criticizing the courts, that are criticizing the judges with regards to decisions made by them. I believe that in this particular case, we need to work on better interaction with these authorities. And I believe that the HQCJ and the courts should have press centers. We also need to have judges, speakers who will communicate our key messages so that we don't have any ungrounded complaints just because somebody is a member of the judiciary. As far as the second question is concerned about the work of PIC and its interaction with HQCJ, in my opinion, it's a valuable contribution to the elevation of trust in the judiciary, since the public has an opportunity to provide their opinion with regard to this or that candidate judge or judge. At the same time, it is my view, based on the analysis of current legislation and my own experience of completing qualification assessment, even though there was no negative opinion with regards to my candidacy from PIC, having watched a number of interviews conducted by the previous HQCJ, I believe that we need to introduce some amendments into the legislation. We do have very strong requirements for a member of the Commission, and it is seen from the legislation that a member of PIC is a highly qualified professional, but there is no explication as to what it means. The legislation also doesn't specify the age and professional experience requirements. Also, nothing is mentioned about the criteria for the assessment of the level of integrity, professional competence, and other criteria necessary for members of PIC. I'm all for cooperation with PIC, but in my opinion, we need to develop clear, mutually understandable relations. I think we need to set out a set of criteria with regards to members of PIC. Perhaps there could be some kind of assessment or check applied to them in the same fashion as we have them for members of HQCJ or candidate judges and judges. I also consider it expedient to work out a clear-cut mechanism of interaction between the two bodies. So there is an announcement about a qualification assessment or an interview. Then we need to specify the procedure. For instance, how many days or how much time should the PIC have to provide their opinion, so that the other party, the candidate judge or the judge, can provide their explanations with regards to that negative opinion. And then, after analyzing information provided by both sides, we can make our motivated, justified decision with regards to every candidate. And if there are some facts communicated by the PIC that has been proven, it means that this person will not complete the qualification assessment and will not be recommended to be appointed as a judge. At the same time, if the conclusion of PIC does not find any confirmation, I believe that we also need to respond to such cases and think about ways to avoid unmotivated claims. Thank you.
Well, thank you for your answer. I'm going to invite my colleague, Judge Verlanov, to ask his questions of you now.
Thank you, Ted. So, Victoria, when explaining your motivation to become a member of HQCJ, today you mentioned that the level of knowledge, your moral and ethical qualities give you the right to become a member of HQCJ. So my question is as follows. Do you have any experience of working in collegial bodies? And if yes, what were those bodies? Yes, thank you for the question. As I already wrote in my motivational letter, and nothing has changed since then, I've never been a member of the Council of Judges. I've never been a delegate to the Congress of Judges. But at the same time, I was trying to enhance my authority by working in panels of judges. The commercial court of the city of Kyiv has a high workload. We do have many complicated cases that we are hearing. I'm going to be frank here, and we need to involve 2 judges additionally. That is why we were hearing many of our cases in panel. That is why I do have this experience of working with other colleagues. So I was part of a panel of judges. Thank you, that's clear. Throughout your career, have you had any experience of assessing candidates that applied for a specific position? Thank you for the question. I had this opportunity only while working as a judge and interviewing people for the position of a secretary and assistant judge. So I've conducted around 20 interviews with assistant judges, potential assistant judges and secretaries. In my opinion, those people who were appointed by me proved to have a required level of knowledge, and they were recommended to be appointed. Some of them are already working in other courts. For instance, my assistant who worked for me, I was not mistaken in recommending her. So my assistant, who's worked with me between 2014 and 2020, she successfully passed the exam, and she has been recommended to be appointed as a judge of a trial court in the city of Kharkiv. Yes, that's clear. Thank you, Victoria. Another question. How would you assess the existing procedure of qualification selection of judges? Do we need to introduce any amendment into the existing procedure? And if yes, what should those changes or amendments be? Thank you for the question. If we are talking about the qualification assessment of judges, then, in my opinion, we should be talking about incumbent judges, the judges that are serving justice. That is why I'm deeply convinced that it would be expedient to have those test questions available to the public. Should it be 500 or 1,000 questions, but the judge should have access to those questions while getting ready for the test exam. And in preparation for this exam, if the judge has the questions available, they will still need to find the answers for the question, but it will take them less time to prepare for the exam, and they will spend more time on serving justice, on improving qualitative and quantitative indicators. Because if we are talking about career growth or serving justice, if we analyze the situation, the majority of people would still focus their attention on getting ready for the qualification assessment, not on doing their day-to-day work. So this is the main criteria that you'd like to focus on? Not the only one. I would probably suggest an additional practical assignment. For instance, we should give the candidates an opportunity to analyze a decision that has already been made by another judge, so that the candidate could showcase their analytical skills and motivate their answer. In this way, we will ensure the uniformity of court practice. That's my belief. Thank you, Victoria. I'm passing the floor to the chair. Ivan, you're welcome. Thank you. Victoria, welcome to the interview.
скасовувати господарський кодекс чи ні?
Should we cancel the commercial code or not? So this is an interesting question, a very relevant one.
Дуже вам дякую за означене запитання.
Thank you for this question.
Трошки зазначити щодо даного питання. Це питання
I
воно є
need
дуже
to tell you that
дискусійним.
this is a question that's the focus of debate, and since the time that I've worked at the High Commercial Court, we were discussing the expediency of the existing of commercial and civil procedure codes.
Постійно в
So
науковій,
it's a kind of dilemma amongst the scholars,
аспірантури і не визначає
and that is the reason why I could not decide what my specialization was, civil or commercial law, but I do support commercial law. That's why I support the commercial code. Yet, many scholars believe that it should be abolished. But you, as a judge, do you often apply the norms of the commercial code? Yes, I do apply them. If we are not talking about punishments or penalties, articles between 180 and 183, do you apply any other norms? Well, I do support the commercial court and the commercial court.
Окей, дякую вам за вашу позицію.
Well, thank you for your position.
Ви в мотиваційному листі
In your motivational letter, you mentioned
треба навчати кандидатів
that we need
та діючих суддів
to teach candidate judges and judges to write their decisions using simple language without overloading those decisions with terminology. Are you able to do that yourself, to write your decisions in a simple way, using simple language? To tell you the truth, in my opinion at least, my decisions are understandable for outsiders. I was taught to write decisions in such a way that a person who has no law degree should be able to read this decision and understand what is conveyed by this decision. As far as the scope of the decision is concerned, I'm a little bit worldly because I try to motivate everything in my decisions. So there may be some questions with regards to the length of the decisions.
А коли ви так робите, ви орієнтуєтесь,
And when you are writing your decisions,
можливо, якісь рішення інших
do
суддів?
you maybe
чи інших
use
суддів?
the decisions of other judges or other courts?
Дуже дякую вам за запитання.
Thank you very much for this question. Definitely,
Як колег,
I look at the decisions of my colleagues as well as the decisions of judges of higher courts.
я обов'язково промоніторю за
I always monitor using the e-document flow system. No. Maybe I was not very correct in formulating my question. It was not about you considering the existing practice. I was asking about clear-cut, very precise language. So there are some judges of the Supreme Court who use this approach of simple language, and there are justices who are very conservative about their decisions. So if you're the proponent of simple language, do you use any templates? Do you use any available decisions? Or have you developed your own template, maybe? Well, thank you for the question. I probably don't have a template of my own, but I analyze the practice with regards to a specific category of cases. And if I like the motivation, regardless of the last name of the judge, it's not that I'm trying to review only the decisions of one specific judge. I look at the category of cases. That's why I'm using from the experience of other judges and their style of making the decisions. And what I like is being precise and motivated in decisions. So I have my own attitude with regards to this issue, because very often judges say that writing a decision in a simple language takes you 3 times as much time as to write it in a more conservative way. And this is their main argument for saying that they don't like this approach. So how does it happen for you, and what would you reply to those judges who say they don't have time to write these clear-cut, precise decisions? Well, if I talk about me personally, I managed to find this time. I sometimes stay at the courtroom after hours. I sometimes work at weekends. But the main thing you need to have is the desire to do it. In answering the question of my colleague about the communication with the public, you say that we need to enhance on the position of the judge speaker, enhance on their status, improve the institution of the judge speaker. So does it mean that at the moment something is wrong with judges speakers? Thank you for this question. I don't think there are any serious drawbacks with the institute of judge speakers, but there is always room for perfection. And we need to open as much information as possible with regards to high-profile cases so that people are aware that there will be a hearing. And we also need to inform the public about the decision made. Many courts have pages on Facebook, they have some kind of information policy, they publish news on the website of the court. That's the great contribution made by judges speakers, but not all courts have this, and maybe we should highlight the positives of the judiciary. As a specialist, as a professional, you were formed within the High Commercial Court of the city of Kyiv, but at one moment in time, the reputation of this court left much to be desired. And it was one of the many reasons that led to the reforms that we are all aware of. You, as a person working at the High Commercial Court, your personality as a professional was formed there, and it is there that you decided to continue working as a judge. So, in your opinion, what were the mistakes made by the High Commercial Court with regards to its own reputation? And what can we do to prevent making the same mistakes in the future? If there were those mistakes, or maybe everything that happened just by chance. Thank you. Thank you for this question. Yes, as a professional, that was my alma mater, if we can say so. And while working at this court, I made the decision for myself that I wanted to be a judge. I worked at that court up until 2011, and in my opinion, we did have highly professional judges there. They were people with whom we could always discuss court practice. They could always draw your attention to some important aspects and things, but at the same time, the court was practically liquidated, but we have questions not just with regards to this court, but also with regards to the High Administrative Court, High Specialized Court for Civil and Criminal Cases. Perhaps indeed there were some mistakes, but we can always improve on some of the things that we are doing. Thank you for this very diplomatic answer of yours. Do we have any other questions from our colleagues? Yes, Yevhen, you're welcome.
No, we have some time limits, actually. Pani Viktoriia,
Victoria, let us continue our discussion about the role of psychologists in the selection. And I have to tell you that, unfortunately, among the candidates who have applied for our selection, we don't have any professional psychologists. We have experts in criminology, but we don't have psychologists. So within the context that we have already discussed, the expediency of involving psychologists for running some additional tests in order to reveal some weaknesses of the candidates. So do you consider it possible, and in what way, to maybe outsource companies or specialists who are knowledgeable in this sphere and who could potentially prepare some tests for HQCJ? Do you consider it possible to involve these specialists or companies? And how are you going to assess their conclusions? Of course, if you become a member of HQCJ. Thank you. Thank you for the question. Yes, the interviews with the candidates that I watched, candidates to be selected as members as HQCJ, so none of them mentioned that they had a degree in psychology. So answering your question, I do believe that it's necessary to involve psychologists. A quality interview with a psychologist will only bring some positive knowledge for us. Since we're not going to be having specialists on HQCJ, maybe it would make sense to outsource specialists or companies that are knowledgeable in this sphere. And my final question, it's rather concise, but I do believe that we have to discuss it. So your mandate expired in 2016, and you were awaiting for the prolongation of your mandate up until 2019. It was quite a long time. I did not have a mandate for only 9 months, and it drove me crazy not having the mandate. So could you please tell us, what were you doing during this time period when you could not administer justice? So how did you enhance your professional competence, maybe? Thank you. Thank you for the question. Yes, indeed. My mandate expired in 2016. So at the time, there was a draft law introduced about amendments to the law on judiciary and the status of judges, and one of the norms in that draft bill gave me an understanding that it was great that I occupied my position for 5 years, but I had to complete a qualification assessment to be appointed again. That is why I did everything to improve my level of knowledge. I got ready for the qualification assessment. So the first assessment done by the previous HQCJ was a little bit easier, but at the same time I was following the events, I was preparing for the exam, and at the same time you participated in the competition for the appellate court. Yes, thank you for the question. I did apply my documents for this competition, but it happened after I've been appointed. So I was appointed in April, and I applied my documents in September. And I watched some 200 interviews with candidate judges, with, candidates to be appointed to the Supreme Court, and also those completing their qualification assessment. And in the meantime, I got interested in research, and that is why I entered my doctorate. Thank you, Viktoriia. That's all from my side.
Thank you, Judge Lomaka. Like Mr. Burkhuizen, I am an international on this committee, and I have a question to you concerning the appearance of the Ukrainian justice system to its people. Mine does not concern the Mercedes-Benz, but a different facet. I've noticed over the past year what I view as a significant number of very young people who have become judges in Ukraine. They often come from families that themselves have judges or are financially well endowed, and it's not entirely a bad thing. But I think about my experience in the United States as Mr. Burkhuizen thinks about his experience in the Netherlands, and I don't think I've ever met a judge in my life who's quite as young as the judges that I've met here in Ukraine. And the question I have is, they've entered the judiciary at a very young age. Typically, they've become assistants to a judge, and after a while, they themselves have been elevated to the judiciary, and they've been in their 20s, and I rarely have seen a judge in the United States in his or her 20s. And my question, not too different from Mr. Burkhuizen, is should this selection commission not wish to consider as members of the High Qualifications Commission persons who've not had such early opportunities and those who may have a little more gray hair than yourselves? Do the Ukrainian people care about this kind of appearance? We've spoken about opportunities for women today, and of course we're concerned about opportunities for, all classes of Ukrainians. But what is your thought about this? I mean, what is your thought about the idea of having such young judges and then having this commission further elevate those judges to even higher positions when there might be some other people who would be equally well equipped for these high positions? I talk too much, but you understand my question, I think.
Thank you for your question. Yes, according to the previous version of the law on the judiciary, a person who is 25 can become a judge. It used to be the case, and then amendments were made in 2015 or 2016, and the judge can be appointed to the position at the age of 30. That is what our legislation says, and we're complying with the legislation. Along with that, well, probably my age census is a little bit lower than that of other candidates who are more experienced and who have longer work record in the field of law or in the judicial position. But again, I think that I'm not that young. I have got good work experience, the experience of working in judicial institutions. This is 16 years. I know how judges work from the moment of time when the materials of the case get into the court premises up till the point of time when the decision is delivered. So my age cannot speak about my professional competence or lack of competence in this case. And I think that, well, whether I would give this place to a more experienced candidate by age, I mean more experienced by age, well, I would think that no, I think that we should not take this into account.
Just like Mr. Burkhuizen, I do not suggest that you're not very competent. I do not suggest that there's anything unlawful in what is at issue here. Just whether this is the message that we should be sending to the people of Ukraine and whether it's a relevant consideration for our commission as we assess the people that we're going to recommend to the High Council.
Well, thank you for this clarification. There are some requirements concerning candidates for the position of the member of the HQCJ, so I think that we need to take into account professional competences and achievements, since there is no requirement to take age into account.
Okay, thank you very much, Judge Lomaka. I appreciate it.
No further questions? Пані
Victoria,
будь ласка, комісія надає
the
вам
Commission gives the floor to you for the concluding speech,
до 2 хвилин.
and you have no more than 2 minutes, and try to sum up the interview.
Дякую, шановні члени
Thank you, dear members of the Commission. Thank you for an interesting interview. I hope that I have shared with you my vision related to the questions you have asked, and that I've done this both for you and highlighted this information for the public. It's exactly 1 year since you have started performing your commitments of being members of the Selection Commission. So thank you for your job, thank you for your work, your responsible attitude to your work. I am sure that you will really select the best of the best for being recommended to the High Council of Justice for their High Qualification Commission. Thank you for your responsible attitude to work, and good luck in your work.
І ми вам дякуємо за співбесіду.
And we're also grateful to you for the interview. So that's the end of the interview.
Всього вам найкращого.
Good
Бережіть
luck,
себе.
stay safe, goodbye.
Дякую, до побачення.
Thank you, goodbye.